Which language do you prefer? Hmm? Today you're alone. Afternoon cancer.
For the past semester, my name is John. My name is three of us. My name is John Samari. No, for the my name is John Samari, Mr. Sammy Adeli, Mr. Shaka Kabul.
Afternoon.
And for the fifth,
Yes, please. Let be provided with some form of comfort. Or there's a bench there. Already. So
And the supporting affidavit deponed by one Inspector Nicholas Njoroge. In a nutshell, the IO in the face of that application indicates that he is investigating several offenses. Attempt to obtain money by false pretenses, contrary to Section 313, as read with Section 389 of the Penal Code. The other offense, Your Honor, is personating a person employed in the public service. Your Honor, is abuse of office contrary to Section 101, subsection 1, as read with Section 102A. That in 2024.
Your Honor, before counsel proceeds, my good brother and a friend of mine, the PCI, you can check as to what is informed. It is not the prosecution that has been done. Then we'll be able to
witness will be cross-examined on one. It is right that we serve the other party with a notice to cross-examine a deponent. And this affidavit was served I believe when I was in my court, it was served upon the respondents.
You know, if I,
Whoever will be put on the dog and respond, subject to some examination. So I think given the fact that we also received this application just like 45 minutes or so ago, and by virtue of what my colleague is saying, that you will not notice in the state that the deponent in particular affidavit will be subject to some examination.
and to lay the basis of agree with us, that is the position. And on the question that we must have a notice, because then we'll be saying, give us time, let us respond, make a replying affidavit. They also do a further affidavit, then we file a notice to cross-examine. It is general practice rules that once an affidavit has been sworn by the DCI, he takes the dog, he convinces the court, and convinces the councils here. If he's convincing enough, we might not even oppose for 14 days.
Can I have a bite of the cherry on this? Kindly, sorry. You're on record. Appearing for and on behalf of the applicant. You know, this evidence is going down on record. And the substratum of what is going into the record is by way of an affidavit. And I wish to invite the court to section 145 of the Evidence Act in relation to how matters are conducted before court of law, how evidence is harvested. They call their witness into the dock. They examine that witness. We cross-examine. If there is any dent that we have done onto the evidence, they re-examine. By this affidavit, Your Honor, after having laid basis why they want 14 days, allow us to cross-examine that deponent so that we can crystallize the issues and dispel whatever underlying issues that there are about the compelling reasons that they imagine to have in this affidavit.
The IO does not need to go to the dock to be sworn to go through his affidavit because it's already on oath. It is implicit. Your Honor, the reason why we needed a notice to cross-examine the deponent is one, so that we can know in which particular paragraphs that the witness is being deponed and has deponed is being cross-examined. Number two, so that the person who has deponed that affidavit is prepared for cross-examination. I have the I who has deponed this affidavit. He has just come from an operation. He is not dressed for court. The court can have a look at the witness. That is why we needed a notice to cross-examine.
That is the content.
It is not the content. You look at the police standing orders, they require a police officer to attend court and be sworn in a particular dress code. And that is why we needed a notice to cross-examine a deponent. Further, Your Honor, you note that Section 145 of the Evidence Act strictly talks about witnesses. He has only deponed an affidavit. And we'll be asking the court to be guided by that affidavit in granting that the state has requested.
Application that we have before you, it is important that we do not lose sight of the consequences of that application. It's an invitation to the court to limit the rights and fundamental freedoms of the suspect.
And if we are to borrow Ronald Dworkin saying that we need to take rights seriously, to casually dismiss the import of cross-examination,
The investigating officer or the court to appreciate the merit or otherwise of the application before it, Your Honor, I think is doing the respondent a great disservice. So we invite the court in the circumstance to allow us the opportunity of using this engine called cross-examination to understand the merit or otherwise of the application before court. There are a number of issues, questions of fact that we will wish to confront the investigating officer on began during the process of cross-examination.
Yes, giving reasons as deponent in the supporting affidavit, seeking to have the first and seek respondent remanded at Capitol Hill Police Station for 14 days so that I can finish my investigations. Your Honor, as the counsel said that we want to cross-examine me, we can go through the supporting affidavit, paragraph 1 to paragraph 9, and if we have any questions, we can ask. Granted by this court as prayed. And after investigations, the case be mentioned, and also I will update court. Yes, one.
Will not give his bear of any annexure. It is just your affidavit and the application that you have presented to court.
Yes, Your Honor.
Now, I'm interested to know, but before I even get there, that all this you are springing into action was orchestrated by intelligence, the intelligence that your office has paid.
Yes, Your Honor.
Now, of that intelligence, and I want now to go to paragraph number 9 of your affidavit. Let me start with number C, 9C, ongoing investigations. Is there any other case that your office is handling where there have been previous investigations that are ongoing against the first, third, fourth, and fifth persons?
No, Your Honor. Your Honor. I've stated very clearly the ongoing investigation. That is the case I'm handling.
Or this current case is what you meant? Okay. If then this is the current case that you have you are investigating on, please confirm to court again that you have not identified any company that is of interest to cover your web of investigation. I mean number 9B.
I have some companies.
And that company is not is not named in this pleading, is not named in these papers that you presented for the court.
Yes, Your Honor.
Thank you. And those companies are incorporated within the Republic of Kenya.
And also outside.
We're imagining that most of the companies are incorporated within the Republic of Kenya.
No.
Okay. Now, does any of the respondents, now when I say any of the respondents, I mean first, third, fourth, and fifth, is there any one of them who works at the company registry?
No, Your Honor.
is there any information that you have received of any of them interfering with maybe filing returns or doing falsification of, records at the company registry?
No, Your Honor.
And is the Office of the Registrar of Companies aware that you are doing investigations on any named company which is of interest in your way?
That's why I'm seeking more time to contact them.
And confirm that this is information that you can receive at the click of the mouse in your computer.
That's not our procedure.
Sorry?
That's not our procedure. We
No, no.
we write
If you
formally
wanted,
to the
if you
company.
wanted to know the particulars
No,
of
no,
the
we-
directorships or anything of the status of the company, you can, at the click of the mouse, you get it.
Council, we don't work that way.
Now, that is what I'm asking. That at the click of the mouse, you can get all the CR12 and everything which is contained by the registrar of companies.
You can.
You can. Okay, thank you. Now, is any one of the respondents that we are representing, the first, third, fourth, fifth, have you gotten information that any one of them has tried to interfere with the system that you cannot be able to get what you are looking for?
That's what we have been investigating in this
Is
case.
there any one of them that you have received information that
no.
he has tried to interfere?
No, Your Honor.
Is there any one of them that you found in possession of items or official documents from the registrar of companies for that purpose of maybe falsifying the registration of the company?
I'm not getting your question very
Is
well.
there any one of the respondents that you got information that he proceeded to have the original file as kept by the registrar of companies to go and falsify those companies of interest which you do not know?
And that's why I'm saying,
The question I ask is very simple. Is there anything that you found in their possession where you now allude that you have gotten them with documents that are kept by the registrar of companies, perhaps with a view of falsifying the same, so that your end result of the investigation is going to be what?
no.
No. Thank you. Now, let me get your number. Visit their passport to the court if they have one, or if they give a contact person and they report to you every day of your investigation, even if it takes 6 years or 10 years, every single day of the investigations that you're undertaking, so that you can cover the web of what you want to investigate.
You'll be guided by the court.
So, do you have any trouble? That's what I ask. You're very troublous.
For me, first I want to finish the investigation, and then if there is anything court will order, then we talk.
Now, what time did you come into contact with any of them? Now, the six, what time did you come into contact with them?
On 22nd at night.
On
22nd
at night,
Yeah.
long before they were the 23rd. You know, they were arrested on the 23rd. Right? Now, if you arrested them on the 22nd, that was on Saturday, right? It was on Saturday. Okay?
That's the time of the booking.
Yes, it's all right. That's my next question. Now, have you demonstrated whichever attempt that you have made from the time you took them in up till today, that you have made an attempt on this end and an attempt on the other end, so that now to show that you have a skeleton of investigations, so that now you ask for the court to give the flesh with the time that you're seeking for?
Your Honor, I've done a lot. This is the file.
Sorry?
I have the file. And remember, it was on
Have
weekend.
you demonstrated, that was my question, have you demonstrated by this affidavit the extent that you have moved from the time you took them in or you had contact with them, that this is the skeleton of what I've done? I've made a letter to the registrar of companies, I've contacted the HR of maybe the Prime Cabinet Secretary's office, and any other.
No, I've not attached
You've
it.
not. I think in the interest of time, I'll leave it with the rest of
Your Honor, that you have already taken the fingerprints of the respondents before court.
Yes, Your Honor.
Thirdly, you confirm that the charges that you think establish the charges that you want or you desire to charge them with, isn't it? So, with regard to many others, you are aware you can even amend a charge sheet later on, isn't it? Now, you reconfirm to the police to aid in the investigation. Is that correct?
Yes, Your Honor.
Perhaps the very last questions are, you have showed to court a very fat file that you have, isn't it?
Yes, Your Honor.
14 days to detain the respondents at Capitol Hill. Is that the position?
Yes, Your Honor.
So lastly, so what will they be doing for the 14 days at Capitol Hill? Have you been able to establish or tell the court what they will be doing for 14 days? The respondents, not you, the respondents in custody. You have taken everything from them. Have you established in your affidavit what then they will be doing for 14 days? Eating government food. Yes.
Maybe I didn't get your question very well, but investigation is a process.
Yes, I have no problem. I'm just asking, just in closing, so that we pave the floor for the learned prosecutor. Have you in your affidavit informed the court what they will be doing, the respondents, not you, them for 14 days?
No.
No, I have no further questions. I thank you on the court.
I on the dock as the compelling reasons he has, and the city to have the respondents detained for 14 days.
By providing compelling reasons as known by the law and as known by the authorities that the court is aware of. Number two, Your Honor, the circumstances of this matter, to bring to this, the court's attention, the circumstances of this matter relies on the fourth respondent, who is the director of the media press director at the office of the cabinet, prime cabinet secretary. This is a matter that has no criminal element at all. This is a matter where the respondent is being dragged to you because people want that office vacant. And several attempts, both criminal, have been done. So there is no criminal element in this matter. The investigating officer has confirmed there is no complainant. The prime cabinet secretary is not the complainant. The complainants are allegedly out of the country. They have not recorded a statement. Neither have they recorded an OB. An investigation in this country is triggered by an OB and a statement by the complainant. And that's what our position is, that this position of the director is so lucrative, they want the fourth respondent out of that office. They replace him once he takes freedom. the state admits that them they have no problem you releasing them because they have failed to give you reasons. And that is why the investigating officer is saying, we leave it to the court. So that the court looks bad when it denies liberty to the 6, not the state, because the state has run away. It has said, let the court carry the skunk. Then we urge the court to stand firm and rely on 2 authorities. And I urge this court to be the first court to implement the micro-teach decision. Many of your brothers and sisters have been afraid to implement these authorities that let the state come with a withholding charge. And that will completely stop the police coming with miscellaneous applications, which is completely an abuse of the court process. 14 days. Then the state walks in and says, sorry, we have found there is no evidence to charge these people. Then we urge, you are aware of that is miscellaneous criminal application number 304 of 2016, micro-teach versus the Republic. Justice Kimaru, out of this decision, he went to sit at the Court of Appeal. That was a landmark jurisprudence. You know, still, the Oscar Sudi case, which is the criminal revision number 208 of 2020, Oscar Kipchumba, that time he was crying for the courts to help him. It's no longer the same today. Justice Professor Ngugi clearly put it and protected Oscar Sudi then, who was crying. That the court should look at the least measure that it can apply to protect the liberty of the people appear before the court. And you know, had the court not protected Oscar Sudi, he could not be the engineer he is today. We urge the court to look at these innocent Kenyans from that lens. Only the judiciary can protect the rights of these citizens from the state. Then lastly, these people are modest businessmen and one public servant. We propose that a cash bail of 200,000 shillings, which they can borrow from some of the students here who can contribute. So that, Your Honor, my colleagues are saying that should be the maximum. Yes. You know, the court can overrule me and say 100,000 shillings. Yes. And put conditions daily. You know, tomorrow we know the country's state of affairs. The Gen Z have threatened to be on the streets. The state needs the services of the fourth respondent to fight the social media wars as a director of communication. Release him now so that he can protect the country communicate what the government wants the citizens to know. He does not need to be in police cells for 14 days. In this matter, because this is a straightforward matter, the state has failed, Your Honor, you'll only take 2 minutes to just pen the ruling that they go home and they pay the cash bill here. We really don't need another day for the ruling. That's all, Your Honor.
You know, they have had to be without their mom from, you know, she also helps and also go to school.
I wish to thank everyone that this application has come later in the day. I even thought it was going to another court, but I think duty calls when I was called upon to entertain it. And I wish to appreciate each party for their contribution. I think the issue of this pre-detention, you know, is getting traction in the jurisprudence of our country, yeah? And I think in the few years to come we won't be having such, yeah? That's my prayer. But I think it's actually 20 minutes past 5. As a lower court, we are not supposed to sit after 5 unless with express authority from the Chief Justice. I have to admit I don't have that authority. And so I won't want to make any pronouncement as been requested by Mr. Nyaberi. So what I'll do, I'll reserve the ruling for tomorrow. I'll reserve the ruling for tomorrow at 2 p.m. So 2 p.m. because I have other matters and, you know, each one of us are equal before the law. And I should not appear to be giving one party an advantage over the other, or precedent, you know, against that. So I'll try at 2 p.m. We'll render that decision. The mother of all. The mother of all protests by the Gen Zs, yeah? So unfortunately I have 2 more judgments for tomorrow. And I won't want to give you a time and then it is not ready. It will be actually even worse than, you know. I won't want to tell you to come at 9 and then I tell you come later. So I'm requesting that you just be patient. It's actually late in the day, yeah? So we come back at 2. I'll come up with a very brief ruling. And so that I also, exactly at 2, we hope that we'll be able to access the court. While you're on the streets. So I think we'll accommodate it. Let's see how it goes, yeah? If you're not able to access, then we can do it virtually. And then since we'll be here, God willing, we can, if, depending on the direction of the court, we'll be able to process everything, even in their absence, yeah? Yeah. So we come back tomorrow, God willing, at 2 p.m. So they will, where will they be detained in the meanwhile?